Hello, everyone, and welcome back. Before we get started today, just a quick reminder, if you could please take a moment to like and subscribe on whatever platform you're using, it really does help us out.
It does, and we appreciate it.
All right, let's jump in. Today, we're looking at a piece of legislation that, and this isn't an exaggeration, pretty much saved the entire machinery of the U.S. bankruptcy system from grinding to a halt.
We're talking about Senate Bill 3424, the Bankruptcy Administration Improvement Act of 2025.
Which is now Public Law Number 11976.
Right. President Trump signed it on February 6, 2026.
And what's really interesting here is the speed. I mean, we always talk about legislative battles, but this one was different. It was introduced by Senator Chris Coons, a Democrat, on December 10th, 2025.
And you look at the co-sponsors, Lindsey Graham, Cory Booker, Marsha Blackburn, a very bipartisan group.
And it just flew through. It passed the Senate by unanimous consent on the very same day it was introduced.
The exact same day. Then it went to the House, they passed it by a voice vote, and that was it, done.
It just shows when there's a real threat to the basic infrastructure of the legal system, things can move. And the system was, really running on fumes.
That's the perfect way to put it. The U.S. bankruptcy system is, it's designed to be self-funding. The whole idea is that it doesn't run on your tax dollars.
A user fee model, essentially?
Exactly. The people using the system pay for it. But that entire model was breaking down because of one single number that hadn't been changed in over 30 years.
And that gets us to the Chapter 7 trustee. These are the people on the front lines, right?
They're the gatekeepers. In about 90% of personal bankruptcy cases, what they call no-asset cases, the trustee is the one doing all the work. They're usually attorneys or accountants.
They're reviewing all the paperwork, checking for fraud, making sure someone isn't hiding a boat somewhere.
Correct. And for all that work, their pay was set back in 1994.
At $60.
$60. That's a $45 statutory payment plus a $15 surcharge from 1994.
I mean, if you adjust that for inflation.
It should be over $125 today, easily.
So for 3 decades, these professionals were effectively taking a pay cut every single year.
And they just couldn't do it anymore. The sources talk about a major brain drain. Experienced people were just quitting the trustee panels. They literally couldn't afford to work for $60 a case.
And that creates a huge risk for the whole system. You get what's called under-investigation.
Exactly. If the trustee is underpaid, they can't afford to spend the time digging. They might miss hidden money. They might miss fraud. The whole integrity of the system starts to crumble.
So Senate Bill 3424 comes in to fix this. And the fix is simple.
It basically doubles their pay. The total moves from $60 to $120 per case.
The base pay goes from $45 to $105, and that $15 surcharge stays.
Right.
But here's the crucial question. If you double the pay, do you double the price for the user? I mean, these are people who are literally bankrupt.
You can't. That would defeat the purpose. So the bill is very clear. The filing fee for a Chapter 7 bankruptcy stays exactly the same, $335.
So where does the extra $60 come from?
It's a clever bit of legislative reallocation. Think of that $335 as a pie. The bill just changes how that pie is sliced up.
Oh.
Before it, a bigger chunk of that fee went to the U.S. Treasury and other government funds. Now, the law says the private trustee gets their $105 right off the top, plus the surcharge. The government basically agreed to take a smaller slice to keep the system running.
So they're prioritizing the people doing the work over the immediate government revenue.
In that one transaction, yes. But they aren't losing money overall because, the system is all interconnected. They make up for it somewhere else.
Which brings us to the corporate side of bankruptcy, Chapter 11.
Correct. Chapter 11 is for large company reorganizations, and those companies pay something called quarterly fees.
And those are based on how much money the company is spending while it's in bankruptcy.
Exactly. It's based on their disbursements. The bigger the company, the higher the fee. And this bill does 2 things here. First, it extends these fees for another 5 years through 2031.
And second,
It raises the cap on the fees for the very biggest cases. For companies disbursing over $1 million, the maximum fee they can be charged is now $281,250 per quarter.
That's a lot of money, over $1 million a year just in court fees.
It is. And here's how the books get balanced. The bill specifically says that $5.4 million of these Chapter 11 fees have to be deposited into the General Treasury Fund every year.
So the big corporate bankruptcies are subsidizing the consumer bankruptcy system.
That is the interconnected system in action. It keeps the whole thing self-funding. And it actually goes further. The CBO estimated this bill would contribute about $27 million to deficit reduction over 5 years.
It sounds like a pretty clean solution then. Fix the trustees' pay, keep it self-funded, even cut the deficit a tiny bit.
On its face, yes. But there was another fire this bill had to put out. And that was inside the judiciary itself.
The judiciary cliff.
Right. You have to remember, bankruptcy filings go up and down. They spike in a recession. So Congress doesn't like to create permanent, lifetime judgeships for a workload that changes. Instead, they create temporary judgeships.
And temporary means they expire.
Exactly, usually every 5 years. And if Congress doesn't act to extend them, that judicial seat just vanishes when the judge leaves. It creates massive uncertainty.
And with filings up almost 12% year over year in July 2025, that uncertainty is a big problem.
A huge problem, especially with business reorganizations, which were up over 80%. So this bill extends 25 of these temporary judgeships from 5-year terms to 10-year terms.
And that's especially important for places like Delaware and the Eastern District of Virginia, right? The big corporate hubs.
It's critical. Those courts handle almost all the major corporate cases. Without these judges, the system would get completely backlogged. This provides stability for the next decade.
Okay, so the bill secures the trustees and stabilizes the judges. But when we look at legislation, we always have to ask what or who got left out. And there was a lot of debate around this.
There was. The main criticism centers on what people call the inflation double standard.
Let's break that down. Congress looked at the $60 trustee fee and said, okay, inflation has made this unworkable.
Right. They said, it's obvious we have to update this number. But consumer advocates, like the National Consumer Law Center, immediately pointed out that other numbers in the bankruptcy code are just as old and just as damaged by inflation.
And they're talking about debtor exemptions, the property a person gets to keep.
Exactly. Take the homestead exemption, the amount of equity you can protect in your house. In many states, that number has been frozen for a decade or more. Home prices have shot through the roof, but the amount of your own home you're allowed to keep hasn't changed at all.
So you could lose your home because of inflation, but at the same time, Congress is using inflation as the reason to give the lawyers and accountants a raise.
That's the friction. It comes across as a one-sided modernization. The system's administrators get an inflation adjustment. The families trying to get a fresh start do not.
And it wasn't just individuals. Small businesses were also kind of left behind here.
That's right. In 2024, the higher debt limits for Subchapter V and Chapter 13 expired. Those higher limits were a lifeline that let more small businesses reorganize instead of just shutting down.
And this bill didn't bring those back.
It didn't touch them. And critics said this is a perfect chance to do it, but it didn't happen. So now some of those small businesses are forced into that really expensive Chapter 11 process where they just have to liquidate.
It feels like they fixed the engine of the car but didn't fix the broken door handle that stops some people from getting in.
That's a really good way to put it. It's a maintenance bill for the operators, not a reform bill for the users.
I want to talk about potential unintended consequences. I mean, you double someone's pay, that's going to change behavior. What's the downside?
Well, there's a real concern about what some are calling over-scrutiny.
Meaning the trustees now feel they have to do more to justify getting $120 instead of $60.
It's a possibility, yes. For $60, a trustee might have looked at a case, seen it was clean, and moved on. For $120, do they feel pressure to dig deeper, to hunt for tiny, questionable assets just to show they're earning the fee?
So a simple case could get dragged out.
It could. It might lead to more litigation over small things, which means more stress and higher legal fees for the debtor. And on the corporate side, you have the risk of what you might call a reorganization tax.
By keeping those really high quarterly fees in place for another decade.
It could scare some companies away from Chapter 11 entirely. They might look at the cost and decide to do an out-of-court workout instead.
Which sounds more efficient, I guess.
It can be, but the catch is a lack of transparency and protection. In a bankruptcy court, a judge is there to look out for everyone, employees, retirees, small suppliers. In a private backroom deal with big lenders, those groups can get left with nothing.
That's a fascinating ripple effect. It's not just about the cost, it's about who gets a seat at the table.
Exactly. If the public system gets too expensive, the private, unregulated system gets bigger.
Out of curiosity, how do other countries handle this? Is this flat fee model for paying trustees a uniquely American thing?
It's somewhat unique in how rigid it is. If you look at, say, Australia, trustees often work on an hourly rate or get a percentage of whatever assets they recover.
Hourly sounds like it could get very expensive.
It can. It can eat up an entire estate. Canada has a more flexible tariff system. The U.S. has always stuck to the flat fee because it provides cost certainty. You know, a Chapter 7 costs $335, period.
But that low fee is what led to the crisis in the first place.
It's a really difficult balance to strike. Predictability versus providing enough incentive for a thorough job.
So, if we look back at Senate Bill 3424, what's the final takeaway? It's the law now.
I'd say it was an absolutely critical maintenance bill. It prevented the trustee system from collapsing, it gave the courts stability for 10 years, and it did it all without raising taxes.
It fixed the machine.
It fixed the machine. But it didn't really do anything to upgrade the experience for the people who rely on that machine. It didn't address the economic realities that are forcing people into bankruptcy in the first place.
So it solved the administrative crisis, but kicked the can down the road on the bigger social questions.
I think that's a very fair way to look at it.
Before we wrap up, I want to leave our listeners with one final thought from all this. We saw that our government can, when it wants to, act with incredible speed passing a law in a single day to account for inflation when it impacts the professionals who run the system.
And it really raises a question. What does it say about our priorities that we haven't been able to do the same for the very protections, the fresh start, that are meant for the actual families going broke?
Something to think about. Thanks for listening, and we'll see you next time.